other than charge conference issues, which I assume will be coming shortly, any other issues that anyone would like to raise, any objections before they start getting down to business? Anything from the state?
No, Your Honor.
Anything from the defense other than charge conference issues?
Not other than those, Your Honor.
All right. The audio for the streaming is back on. Defense, the floor is yours.
Your Honor, let me just start as a blanket statement by renewing our past objections during the charge conferences yesterday.
Noted.
Wednesday. I would note specifically in the charge as given, which I presume will be a paper copy of which will be included in the record of the case.
So to be clear, I'm going to hand this copy to the, well, I'm not, but the bailiffs are going to hand a copy of the jury instructions, the verdict form, and the indictment. And if you would like to make a separate, short version is my expectation it'll work its way back to the court reporter. If you'd like to do that now, that's fine with me.
As long as it works its way back, my concern is that should this become material in some other proceeding, that my references are clear. But I was going to use the page numbers for that purpose. That's
handle it any way you want, and we can double check on that. But so I have the jury instructions in my hand, the indictment, which everyone can view before it goes back, and then the verdict form, all of which are clean, for lack of a better term.
Right. So I think I can make this clear enough regardless, but I would hope that the paper charge was included in the record by the time we were done.
So I'm directing that the jury instructions come back from the jury deliberation room and the court reporter take possession of said charges. If you'd like to tender a copy now, that's fine too.
I've marked up my copy, Second Judge, so.
I can have Mr. Preston print it out if that's what you want to do.
I'd be grateful, but I hate to impose on Mr. Preston more than we already have.
Mr. Preston will shortly print out the last version, which is the version I read from, and that will be Court 1, C1, Court 1.
Thank you, Your Honor. All right.
Thank you.
So on what will become...
I apologize.
Oh.
They're taking a break for an hour. The jurors.
So we'll start at 2:15. I'd like to know when they start deliberating.
Well, yes. I mean, safe to assume, I mean, the note, it says going out for 1 hour. And it also gives the name of the foreperson, which I'll share with y'all, not on streaming.
Can we be notified when all the jurors are back and they begin deliberations? Thank you. Ms. Bradley? What?
Sorry. So, Your Honor, for purposes of protocol, since that's happened, I think the note should be marked C2.
I would agree.
Thank you. All right. Now, getting back to where I was before. On page 8 of what will be C1, where the court gave the pattern charge 2.10.20 on felony murder, we objected did not include the language regarding inherent dangerousness. As I noted to the court, our position is that the 6th and 14th Amendment under Apprendi and the cases that follow. I'm sorry. I apologize, Madam Court Reporter. I did not have the microphone. But under Apprendi versus New Jersey and the cases that follow it, that is a question of fact that has to be determined by the jury, not determined by the court. Relatedly, we would object to the courts not having given our request number 39, which covered the same material, as well as our request number 40, which provided a definition of inherent dangerousness, or at least that the charge should have contained some definition of inherent dangerousness. All right. On courts, I guess C1, page 11, where the court instructed 2.20.21. Our objections, which the court has heard before, are that we have now instructed the jury that there are alternate ways of committing an assault. Remains our position that the state should have specified one way or the other, or have put forward separate charges, as it undermines the certainty that any verdict would be unanimous. Related to that, I would point to the verdict form on counts, as provided on counts 2, 4, and 6. None of those counts contains any specification as to the underlying species of assault, and so even if the jury were to return guilty verdicts, we would not be certain as to their unanimity on the underlying species of assault. And should that issue arise, I would re-raise it as an objection to the form of the verdict. Between what would have been pages 11 and 12 of C1, we would object to the courts not having given our request number 46, which relates to the applicability of scienter, as well as our request, I believe, make sure I'm number 48. I guess So I guess, yes, our request number 48, which relates to authority with respect to one's property. Then on page 13, where the court gave the definitions of specific forcible felonies, we object for the reasons noted before, that the court did not instruct on rape as a forcible felony, which was covered in our request number 32. And between pages 14 and 15 of what will be C1, we would object that, or I guess, no, I apologize. On page 15 of what would be C1, well, we appreciate the court's charging on violence and the types of violence that are now admissible in self-defense cases. We object that the charge contained no reference to post-traumatic stress disorder, or that the jury must consider what would have been the actions of a reasonable person who had the same experiences of violence and clinical history of post-traumatic stress disorder as the defendant, which was covered in our requests to charge 37 and 67, either of which was in the alternative to the other, and we would object to the court's giving neither. And I think that does it for me, Your Honor. Those are our objections to the charges given.
Thank you so much. I will note the objections from the preliminary charge conference, the charge conference, and as stated at the conclusion of the reading of said charge. Anything else from the defense?
No, sir. No, sir. As long as that constitutes a ruling, I think no.
I think it does, so if it doesn't, let me know. Your requests are denied. Specifically, every request that you've outlined is denied and is contains in the record of our charge conference discussions as well.
Thank you for considering them, Your Honor.
Okay.
Thank you. If the lawyers who are interested in who the foreperson is, I have that information here.
It's, thank you.
Good.
It was the woman that had the blonde with the short hair, the blazer.
Hold on one second.
They have mine. 61, 62, missing 63.
How are these organized?
I don't know, they're like in groupings, and we're just trying to like put the groupings together.
Like, not by number? You don't
No,
want
they
them?
are.
All right, folks, could I have your attention for a few minutes longer, and then we'll take a recess. For the record, C1, I'm handing the court reporter, which is a printed out version of the request to charge, or sorry, the charge to the jury that I read to the jury, and for purposes of the record, C2 is the jury's first note identifying the foreperson as well as stating they're going to take an hour break. That's C2, Court 2. Let's have a plan on evidence. So we'll talk about that in a moment. Anything else that y'all want to talk about before we talk about evidence?
Not that I think of, Judge.
Just want to make sure that the charge of the course that you identified as
One.
is going to go back along with.
Sorry.
No. To clarify, C1 will remain with the court reporter. That's a duplicate original. This is what I'm going to hand to the chief bailiff, and if y'all would like to inspect it, that's fine. On the jury verdict form, there's nothing on there other than what we agreed. Jury instructions, there's nothing on there. That's inadvertently folded. I don't think that's on page 10. I don't think it indicates anything. And then we have the indictment, which I don't know who did it, but somebody wrote the case number, not me, on various different pages, which I don't think influences one way or the other. But y'all can inspect that. That'll be going back to the 12 assembled jurors.
Yeah.
You said 149?
Thank you.
Oh, I have,
Any other issues other than evidence?
Not the most.
oh, sorry. No, not from the state, Judge.
Okay, so what do we want to do? Is it vacant now?
Yes.
So the deliberation room is vacant now. Do y'all want to have somebody other than me take the door in and place it?
Yeah, I spoke with the deputies, about if they wanted us, I don't know if they want us to put it in the bag and then carry it that way, or if they just want to carry the door as is. I mean, it's honestly up to the deputies.
Well, I would think, I mean, I'm fine with whatever. I think in the bag probably isn't what they, I mean, if they want to look at it, then whatever y'all decide.
As long as the deputies are okay with just picking it up and carrying it back there, I'm fine with that. We can, there's the stand, I mean, obviously, we're not gonna go back there, but.
Well, there's no one back there, so I'm actually okay with the lawyer supervising if that's what you want to do.
Is there wall space to prop it up, or I could send?
So here's what I want to do. Within reason, y'all can go back there and agree upon where it's going to go. If you need my intervention, I will go back there and we can put on the record. I don't think we'll get to that point, but it's not a super large room.
Okay.
And if anyone, I mean, y'all agree upon it, get the door back there somehow. Let me know if there's a problem. All the evidence, I believe, should fit on the cart here. And do you want to have it in the courtroom and then take it back once they get here, have it waiting on them when they get back?
Waiting.
Okay.
Guns do not go back. I'm leaving those here.
That's fine with me.
Just making sure.
Okay, so here's what we're going to do. Kind of final decision here. I'm going to depart from the bench, and if there's any problems, let me know, and I can make a decision for you. Absent that, coordinate on all the exhibits, put it on the cart, put the cart in the deliberation room, put the door in any manner that you agree upon in the deliberation room, and guns remain in the courtroom. Anything else we need to talk about?
Not the state
We
judge.
just provided our cell phone numbers.
So I think my staff knows how to reach all of y'all. If not, I'll let you coordinate with that, but
Is a hammer on the back of that? All right, I'll get the hammer going back.
all right, I'm going to step off the bench. If there's any problems, I'll be in my office. Obviously, a lot of the time. Thank you. For the record, that being said, the foreperson alleges that one of the jurors is my summary, refusing to participate in deliberations. Now, the court's making no comment one way or the other on that. Certainly don't have any basis of knowledge, but that's the issue that is upon us. They've been 2 hours, I think. I think that's right.
Yes.
And I don't know how many days of actual testimony, but it's been several. So I'll certainly look for inclination, and ultimately it's my decision, but there's several ways we can go about it. One, I bring all the jurors back and I reread page 16 portion where it says you should start your deliberations with an open mind. Pattern. I can bring the foreperson out and inquire further without commenting on the providence of the jury, without interfering with their deliberations. I can bring them all out, and so we have some options, but it is, in the court's estimation, very early in the process as far as deliberations. I make no comment on the length of any jurors or jury's deliberations, but I don't know, after 2 hours, we can already be at a deadlock, but that's the issue before us. State, would you like to start? No? Defense, would you like to start?
He can start.
Well, Judge, I have Mr. Bullard looking at this right now. I think, and I could be wrong, but I believe that I think the rule is that the lawyers have a right to see the note.
So on that point, I believe there's a split of authority. I think the preference is that you receive a copy of it. However, I do believe that there's backing of a trial judge in at least withholding the information. Certainly it'll be part of the record, and that's not a final decision. I'm just letting you know. I'm not telling you right now, other than the court summary that I just gave you. And I understand that you lodge an objection to that. I understand.
And I'm trying to articulate what the objection, I guess my objection is I'd ask to see the note at this time. And I understand what the court's going to rule.
No problem with you asking. At this point, the court is declining your request over your objection with the response that the court, as a neutral arbiter, is summarizing that the foreperson is indicating that one juror is refusing to deliberate. Now, there's more to it, which I think would give an inkling to the parties of potentially where the jury might be at, which I don't think is appropriate to tell you at this point. But your objection is noted.
May I have just a moment?
Have as much time as you need. I would suggest we do either one of two things, and I'll certainly hear from y'all. Either bring everybody back, I read them the general charge, send them back. Hopefully that doesn't create improper conduct in the deliberation room, which again, I don't anticipate. So read in the general charge, see if they do something, and if they still are in this position, send them home and come back tomorrow. That's an option. Inquire further with the foreperson individually, which I believe is proper. Inquire from the foreperson with everyone present, which I also believe would be proper. And then, not at this point, but I think the next level would be to inquire with the individual juror about their understanding of their obligation and oath.
where we are. You have a white sticky for me?
Judge, what is the final page that you would be reading? Is it page 16, you said? I'm sorry.
If you look on the jury instructions, the ones I read to them, page 16, third full paragraph, you should start your deliberations with an open mind, and then it ends with solely because of opinions of other jurors.
Yeah, Judge, I think we're in agreement, we are endorsing your suggestion to bring the entire jury back, read that again, and send them back.
So they just want to read the jury charge. But, go deliberate.
So this here's.
I mean, it is
This one. I think it's just.
we were
this
just
bit.
gonna suggest bringing the court. Yeah, and asking what it means by refusing to deliberate. Like, does it just mean they don't want a waiver, or does it mean they're literally not even like conversing?
Yeah, it hasn't even been 2 hours. I think that would be the safest thing.
Read the thing again, go back, it take them 15 minutes. and
Say
still
he's
refuse
just
to
not doing it,
refuse
then
to
we'll,
refuse.
okay. Okay.
Let me re-review the note, please.
I don't know. I think I just say you forever.
So I'm going to edit, and I understand it's over defense's objection. Court 1, page 1 and page 2. From the foreperson, a juror has declared immediately upon entering room, he will not change his mind, will not discuss and deliberate. We have talked about how we want to understand his reasoning because we are collectively here to reach a verdict and help each other make a decision. He said he is not obligated to change his mind or to be open-minded. He was open-minded in the courtroom. Everyone is concerned and explained they are concerned he entered with bias. And there's a portion which I'm not going to read. He will not explain any reasoning other than it's his feelings and he knows how these things work. We have tried explaining. We value his thoughts and why he thinks that way, and said he won't do that because our opinion is ours and his is his, and he will not try to change our I don't know what it says. Change our plus sign, scratch through. He will not try to change our, I guess it's period. He will not try to change ours. He won't let us try to change his. Foreperson, today's date. So I edited out essentially one sentence which would indicate very likely which way that juror's going.
You good with that? Still good with that? Brett?
With just reading the charge.
Especially the open.
We're,
We have two main options. I can inquire with the foreperson, I can bring everybody out. Obviously, the lesser introductory level would be just to simply reread it. It may not be received well. I don't know if it will or will not.
It's not the notice, it's just the date.
I think we're supporting your suggestion to bring them all out, read that last page, and then send it back. If they come back in 15 minutes and say, we're in the same spot, we'll do whatever. But I think that could be a good thing to just reread the charge and see what happens. Because it's only been an hour and
We'll call it 2 hours, but
2
yeah.
hours.
Okay. Anything from the state?
No, I mean, it has been early, and it's not like reading the charge really does any harm. I just don't know how fruitful it's gonna be based off of the note. I don't think it would hurt to also inquire with the foreperson what's going on without making sure that the foreperson understands not to indicate one way or the other as far as leaning, but I don't really have a strong opinion one way or the other. I'm just not sure how fruitful this will be, but we can try.
Let's just try it and see. It's been 2 hours.
Absent an objection, I'm going to bring them back, read them that one paragraph, send them back to the deliberation room, not to be presumptuous, but should it bubble up again, then I think the next level will be talk to the jury foreperson in open court outside of the presence of other jurors. Anything?
No, Your Honor.
We're good? That's what we're going to do. Let's bring them back. Thank you. And tell them they can bring their jury instructions if they want.
That's what I think too.
For the record, as an email indicated, they asked for individualized printout. So Mr. Preston printed out 11, 12 copies. Welcome back. Thank y'all. Welcome back. You don't have to have a copy. If they wanted to, that's fine. That's not required. Welcome back. We have all 12. Thank you. Y'all can be seated. Madam Foreperson, I have received your note and I've communicated in summary to the lawyers. The response is this. This is to all jurors. And to be fair, I'm rereading a portion of the jury instructions I read approximately a few hours ago. You should start your deliberation with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of opinions of other jurors. Members of the jury, I ask that you return to the deliberation room. Thank you. I certainly don't want to get into the, y'all can be seated, please, thank you. I don't want to get into the guessing game. I would imagine that if they are going to start to deliberate, they would do so. If they're going to potentially disagree, that might be sooner rather than later. It is 4:45. Again, I don't know. Maybe they come back and ask to come back tomorrow. I don't know. The reason I say all that is please don't go very far. Certainly, I'm very open to you doing whatever. I don't require you to remain in the courtroom. But that being said, I think it's a natural observation to say that they may give us information sooner rather than later. So I'm going to go back to my office, which is over there. And anything else we need to talk about?
No, Your Honor.
No, sir.
All right. Court's in recess. Thank you. All right, everyone's here, state's present in the courtroom. It's nothing dramatic. I thought about just sending them home, but they want to go home. So C4, I will show you this, but that's what it says. It's nothing super descriptive.
She's very apologies. I have literally.
All right, so the jury is requested to go home. Go ahead and let them know that they are free to leave for this evening. Actually, let's bring them back real quick, if you don't mind, please. Please, thank you. All right, thank you so much. Please be seated. Members of the jury, Madam Foreperson, thank you for your efforts. We will honor your request, and what will happen is y'all can reconvene. I believe you said essentially what we've been doing, and obviously the bailiffs will kind of check in to make sure you have all 12, but I'm not going to convene the lawyers. So essentially, I'll be in my office. You guys do the work you need to do, and if you need something, then we'll reconvene. But you can immediately go into the deliberation room. Again, do not do any deliberations until all 12 of y'all are present. Clearly, you've heard all the evidence in this case. Do not perform any research online, in person, paper. Google, AI, et cetera, no research whatsoever. Do not discuss the case with anyone. Do not discuss the case with anyone. With that, you're excused for. Anything from the state? Y'all can sit, stand, I'm fine. Anything from the state?
Yeah, no, Judge, sorry.
Anything from the defense?
No, sir.
We're adjourned for the day. Thank you.
Nothing left.
Sheriff's Department's going to let the jurors go by. Thanks.